Good afternoon, everyone. My name is Marion Sandilands. I'm a member of the Nunavut Law Society and a member of the Nunavut Law Society's Legal Ethics and Professionalism Committee. Welcome to today's exciting CPE Lunch and Learn on the duty to report. I'd like to welcome all the participants today on behalf of our committee and the Law Society of Nunavut. Today we have some very special guests from the Federation of Law Societies of Canada. So the Nunavut Law Society is a member of the Federation of Law Societies of Canada. That's the national association of all the law societies. And the Federation of Law Societies has a model code of professional conduct, which the Nunavut Law Society definitely interacts with and follows. And there's processes for that model code to be updated from time to time when new issues arise. So today we're looking at one possible set of updates to that model code around the duty to report. So the Federation of Law Societies issued a consultation report just a couple of months ago in April 2025, and they're asking for feedback from the law societies by the end of this calendar year to help our law society and our committee to better understand what's being proposed. We have invited members of the Federation of Law Societies Model Code Standing Committee, folks who worked on the consultation report to help us understand it. So the purpose of today's Lunch and Learn is a briefing to get us up to speed on the consultation document and the process, and to learn what things the Federation is looking for feedback on. So I'd like to thank very much the Federation of Law Societies for providing us this briefing today. It's very helpful. And in particular, I'd like to welcome our three speakers from the Federation of Law Societies. We have Karsten Jensen, Claire Marchand, and Elaine Cumming. So Karsten Jensen is the chair of the Federation's Standing Committee on the Model Code, and he's also a partner at JSS Barristers in Calgary. Claire Marchand is also a member of that standing committee, and she is the Director of Policy and Practice at the Law Society of British Columbia. Welcome. And Elaine Cumming, also a member of that standing committee. She is the Director of Professional Responsibility at the Nova Scotia Barristers Society. So we are very across Canada here. We're really a coast to coast to coast. That's wonderful. I'm hoping that they'll be able to tell us about the work of the Standing Committee and walk us through the consultation report. So without any further ado, I will turn the floor over to our invited guest speakers. Thank you.
Thanks so much, Marion. I'll start. Karsten Jensen, as Marion indicated, I chair the Standing Committee on the Model Code of Conduct of the Federation. I'm Alberta's council member on the Federation of Law Societies, so each province and territory has a council member representing each of those law societies at the national level. I'm a former bencher and a former president of the Law Society of Alberta. So Claire and Elaine, as you'll have heard from the introductions, provide a great deal of subject matter knowledge on legal ethics matters based on the work they do for their respective law societies, and they are highly valued members of the Standing Committee on the Model Code. They will have realized when I sketched out an outline for today, at some point afterwards, that I'm somehow imposed on them to actually do all the heavy lifting today. So I hope they're good with that, and I'm certainly delighted that they'll be taking that on. As indicated, the Federation of Law Societies operates at the national level and is really the law societies operating nationally in coordination on issues of common interest. That's what the Federation does. And some years ago, the law societies agreed on a national mobility framework, so mobility of practice for lawyers. That's both temporary and permanent mobility, allowing lawyers to move from one jurisdiction to another temporarily and also permanently with less difficulty. There are some special rules involving the territories for obvious reasons, but the mobility arrangement that's in place really created the impetus for having some national rules regarding legal ethics. If lawyers are mobile and can move from one province or territory to another and have portable practices, which many do, it's very difficult to ask lawyers to operate under different ethical frameworks. And so that was really the impetus for the Federation to create the model code, which happened in 2009. Well, it was adopted in 2009 at the national level, and then subsequently adopted on a province and territory by territory basis. And so the model code is just that. It's a model. It is not the code of ethics binding lawyers. It's a model for the various provincial and territorial law societies to consider and hopefully adopt. And in fact, what happens is that we have a fairly extensive consultation process before we make amendments to the model code. This is part of that consultation process and discussion with all of the law societies, and we operate very much on consensus. So, as a practical matter, when the model code is amended, typically the provinces and territories then adopt those amendments in whole or in part in their jurisdictions as may be appropriate. And there are some regional variations for local practice on certain issues where local practice is engaged. I think duty to report is unlikely to be one of those where there are different, substantial differences from one place to another. But of course, we will see. So the standing committee then has representatives from across the country. You have three of those representatives here today, and we're charged with proposing revisions and updates following this consultation process. The last project we completed was with respect to discrimination and harassment, and we substantially modernized the discrimination and harassment rules in the model code. Those were in real need of modernization to bring them into line with current sort of thinking and norms as well as jurisprudence. And so that took place a couple of years ago. And at that time, we considered looking at the duty to report in the context of discrimination and harassment and concluded that that should wait for a broader review of the duty to report rules, which is now where we are. I'm not sure if the consultation report has been circulated in advance of the meeting, but if not, perhaps Amelia, I don't know if you can, but if maybe we can put the link to that report in the chat so that everybody has it available. So following this consultation period, we'll take what we've learned. We'll adjust the proposed wording as may be necessary. We'll take the amendments to the Federation Council, and every province and territory has a representative there. Once passed there, then, as indicated, normally the law societies will adopt their own codes accordingly. It's only then that these changes would be definitive in each jurisdiction. Until then, this is a discussion and a consultation, and we're very keen and eager to hear what everyone might have to say. So quickly on the what and the why, the duty to report as it's currently framed in the model code generates a lot of questions for practice advisors and for law societies across the country generally. It's not a model of clarity. There are some subjective elements to it. And some of the issues that we see and that we've heard about from the law societies across the country with respect to this rule have to do with things like self-reporting. To what extent does the duty apply to a lawyer's obligation to report themselves? There's a reference in the current rule to trustworthiness, which seems to be kind of a subjective assessment made by the potentially reporting lawyer, and it's not necessarily focused on conduct. And we were thinking in our review that rule more focused on conduct. Actual conduct, observed conduct by a lawyer would be more appropriate and less subjective. And also the rule as it's currently framed has a reference to capacity to provide legal services. That also raises subjective considerations for the potentially reporting lawyer. It's hard to measure. And even more of a concern, it's potentially stigmatizing to look at someone and say, well, I don't think that person has capacity to be a lawyer because they may be suffering mental illness or an addiction. But what's the actual conduct? Have they actually done anything that might suggest that they are unable to provide legal services in such a way that ethical duties should be engaged? It's not to say that capacity questions might not come to the attention of law societies otherwise, that there might be programs to help lawyers. There are programs to help lawyers deal with capacity questions. But in terms of conduct, discipline, and ethics, it's sort of this peculiar mixture of the capacity issue with ethical rules that has raised some problems, I think, for law societies in terms of dealing with this, and for members in terms of determining whether or not they themselves have an obligation to report. So that's kind of the backdrop to what we were doing, and looking at this rule. And from that, we really extracted three parts to the review. The first was to look at the wellness aspect of the rule and to consider whether there's something about the rule that is stigmatizing, too focused on capacity and not focused on conduct, and whether that could be improved in a way that would help members of law societies and also help the law societies. We wanted to look at the overall clarity of the rule, that is, to see whether we could frame it in a way that would be easier to understand and easier to apply, so less subjective. And we wanted to consider the discrimination harassment piece to see whether amendments were required as a result of the modernization of the discrimination harassment rules. And so really that outlines our plan for today. Claire is going to start the discussion with a discussion about the wellness aspect of things, and then to talk about some clarity issues in the rule. And then we'll go to Elaine, and Elaine will talk about the discrimination harassment question and how we looked at that and where we landed. And then we'll conclude with some questions and discussion. Of course, discussion is open at any time if anyone has any questions or comments, but there will be a discussion opportunity at the end of that, of this. So with that, over to you, Claire.
Awesome. Thanks, Kirsten. Thanks, everybody, for being here today. So I wanted to start by talking about the wellness aspects of the rule and the changes that are being proposed by the Model Code Standing Committee. So we're all familiar with the National Study on Lawyer Wellness, Phase 1 and Phase 2, that has demonstrated not only a highly concerning prevalence of mental health and addiction concerns in the profession, but also a serious reticence to engage in services to help individuals improve their mental health. This is something that we've been looking at in BC for a number of years. We had a mental health task force that had a mandate to address these issues. And as part of that work we were doing with the mental health task force, one of their recommendations that's been implemented is to change the duty to report rule to take out language that focuses on the capacity of an individual and focuses more appropriately on the conduct of the individual. And I think that ties back to the national study. While there's a prevalence of mental health concerns, there's lots and lots of lawyers with mental health concerns that are absolutely competent practitioners. And we would never want a person to look at a rule like this and not seek the help they needed to improve their mental health for fear of creating a reporting obligation in a third party, or to not engage in the services that law societies support or otherwise to support their mental health for fear of that getting back to the law society. And that's something that we emphasize so clearly at the Law Society of British Columbia, is that an individual will never, ever be disciplined on the basis that they sought help. And so we wanted that language to come through really clearly with respect to this rule, so that an individual would understand their obligations, but also not see those potential fears as a reason to not engage with their mental health and improve it. So the changes that are in with respect to wellness are very similar to the ones that are in the code rule as we have it in British Columbia currently. We've taken out the language about the capacity of a lawyer to provide professional services, coming back to that we want to really focus on the conduct of the lawyer, not having lawyers engage in capacity assessments. And that's another really important thing in this, right? As lawyers, we can look at the conduct of another lawyer or ourselves and consider whether it's met the standard. We're not mental health professionals. And the way that the language was originally drafted put that lawyer in a position that they were almost acting as a thing that was so far outside of our competence. So if we take out that language about capacity, we can properly focus on the conduct of the individual, which is something as lawyers we have the competence to assess. Another thing we wanted to make very clear in the rule, and this is in the commentaries to the rule, is that there is a confidentiality framework that goes around any sort of mental health or well-being supports. And so we kind of thought about that in two categories. You've got individuals that are registered clinical counselors, psychologists, and otherwise, and then lawyer support networks through the Lawyers Assistance Program in the various provinces. And so we wanted to create some language in the rule that recognizes that mental health professionals have their own codes of conduct and confidentiality, and that they will keep things confidential according to those codes of conduct, with very minor exceptions, for example, a real risk of imminent harm and otherwise. But we felt in the rule it was important to name that, but also not have it drafted in a way that it would in any way trump or impede or on the codes of conduct that those professionals have. And then we also wanted to make sure that we were covering lawyer support networks. So for example, volunteers through the Lawyers Assistance Program, to make it clear that those individuals, if I was to speak to an individual at the Lawyers Assistance Program, that I could do so with the confidentiality and candor that I needed to get help, and that it wouldn't create a reporting concern for that lawyer who is there to be a support to me. So I think all of these changes work really well to refocus the rule on conduct, and also take that time to create the comfort, to the extent we can in the code, that there won't be a regulatory implication for an individual seeking to help and seeking to improve themselves. The other thing I wanted to talk about is some of the clarity changes that we made to the rule. When I joined the Law Society of BC in 2017, I joined as a practice advisor, and I've been leading that team since 2020. And as Karsten was mentioning, we get a ton of questions about this rule, and a lot of them are more focused not on, do I have to report another lawyer? It's they don't want to. They want to understand that they don't have an obligation. And so these are some of the common the changes that we've made address a number of the common clarity issues that come up in those practice advice calls across the provinces. So to start with, one of the key changes we've made is to the threshold of the question. So it used to say, unless to do so would be unlawful or would involve a breach of solicitor-client privilege, a lawyer must report. And so we've taken out that language of or would involve a breach of solicitor-client privilege, because it had some unintended consequences, and we were getting lots of questions about how to navigate that. So I think we've more properly moved that into the commentaries of the rule, because in any rule you navigate in the Code of Professional Conduct, you have to think about confidentiality and privilege. And so putting it in a better place in the commentary versus in the threshold where it was causing some confusion. It's also made it clear that the reporting obligation is in respect to themselves or another lawyer. This is language we already have in British Columbia, and I think it's important. We've also, in terms of the sections that are here, reordered them a bit. So having misappropriation, trust money issues first, then abandonment of a law practice, that language has remained the same. Participation in a criminal activity related to a lawyer's practice, that's remained the same. And then we've taken those concepts of conduct that raises a substantial question and broken into two. So we've got conduct that raises a substantial question about lawyers' honesty, honor, or integrity, which Elaine will talk about more when we talk about this in the context of discrimination and harassment. And then we also have conduct that raises a substantial question about a lawyer's competence to provide professional legal services. And the thinking there is to take those concepts like honesty, honor, integrity, and group them together as separate from a competence issue. The other section that we're proposing to remove is, there was a catch-all section F that said, in any situation in which a lawyer's clients are likely to be materially prejudiced. And this one was always hard to answer questions about the practice advice on the practice advice line about, because if you take it to its natural conclusion, the other lawyer doing a really great job is a material prejudice to my client. So what was that supposed to capture? And so recognizing this, we went through that we weren't guiding folks to that rule, and that it wasn't really adding any value to the key things we already had in it. The Model Code Standing Committee is proposing that we just remove it because it's causing confusion, and it's not really adding anything to the interpretation of the rule. Then when we go into the commentaries, there was a couple of things we took the opportunity to clarify that were common questions on the practice advice line. One of them was, if I am concerned about something that another lawyer is doing, do I have a suspicion do I have an obligation to look in to investigate that suspicion? And in our view, that an individual doesn't. If a person has a little bit of information about what another lawyer is doing, they don't have an obligation to go on their own investigation to figure out to honor their duty to report to the Law Society. And so we have some language in there now that makes it very clear that a lawyer is not obligated to report that mere suspicion, which is helpful. And then we've also got some information here too about if the threshold of the rule is met. So if there's a reporting obligation, that they're relieved of that duty to report on the basis that other authorities have been made aware of it. So for example, if something that rises to the level of the duty to report happens and it's reported internally within the firm, that doesn't obfuscate the obligation to also report it to the Law Society. So I think these are all really helpful changes to make it clear. I think it's a rule that I think had a lot of subjective language in it. So we've tried to make the language clearer, a little bit less subjective, and to play the role it needs to play of that the Law Society needs to be apprised of incredibly serious conduct, but at the same time trying to alleviate the concerns of members that where the subjectivity of the language gave them unnecessary concern about what they needed to do to honor their obligations. So with that, I'll pass it over to Elaine to talk about the work we did on discrimination and harassment.
Claire. So back in October of 2022, the Federation of Law Societies Council officially adopted the amendments to the Code of Professional Conduct in relation to Rule 6.3 and all the rules under that section regarding discrimination and harassment. Those amendments followed several years of consultations. For the first time, the Standing Committee actually conducted two extensive consultations. The first came out in January of 2020, which was extremely broad and sought the feedback specifically from law societies and various interested stakeholders across the country, as well as the law society memberships generally. When that feedback was received, it was reviewed and sort of repackaged into another set of draft amendments that were sent for a second consultation to the law societies directly. That was in July of 2021. As I say, the Federation's Council adopted those officially in October of 2022, and the law societies across Canada followed suit over the next several months. With the much more robust and rules regarding discrimination and harassment, what the Standing Committee was left with was a question of whether the current duty to report adequately captured a duty to report potential breaches of the duties related to discrimination and harassment. And that sparked a number of years of conversation about what a duty to report discrimination and harassment should look like. And we went through a number of iterations of a draft rule, both one that we thought maybe would fit specifically under Section 6.3 of the code, so a freestanding duty to report that was specific to discrimination and harassment, or whether we could, with some amendments, tweak the current Rule 713 to ensure that it was clear that a duty to report discrimination and harassment fell there. Our code committee fell into sort of two camps. One that felt that there should be a specific duty on lawyers to report discrimination and harassment, and one that was very concerned about the potential for unintended harms coming from such a duty to report. Just to be clear, the first camp was not unaware of or disinterested in the protecting folks under that duty to report, but felt that there really needed to be something specific. As a result, the standing committee consulted quite thoroughly with a number of interest groups, including representatives of the Discrimination and Harassment Council Office at the Law Society of Ontario, discipline and the Discipline Administrator Steering Committee, so those who at the various law societies who are tasked with actually enforcing the rules and investigating complaints, prosecuting violations of the rules. Among other groups of folks who work in support of roles for those who have experienced discrimination harassment. So we got a lot of feedback, and what we heard, unsurprisingly, was a real fear of including a duty to report and inadvertently causing further harm to those who may have suffered or experienced discrimination and harassment. We did not want to draw people into the complaints process who had not chosen to make the complaint themselves. We did not want to impose a duty to report on folks who could be harmed by that duty to report. So, for example, if you've got an article clerk or a junior associate who is putting their own career on the line by reporting a senior partner. So there was just a myriad of concerns that were not easily able to be addressed in exceptions to the rule. So having a duty to report discrimination harassment with these exceptions, and it didn't work very well. So after a number of rounds of amendments and many discussions, we ended up where we are today with the rule as it appears in this most recent consultation report. And I think we've gone a long way to ensuring that duty to report discrimination and harassment would be included in this, particularly in the change Claire had referred to in what is currently in paragraph D, and now is still in paragraph D, but states that conduct that raises a substantial question about a lawyer's honesty, honor, and integrity. So we felt at the standing committee that is broad enough to capture those duties as set out in Rule 6.3 relating to discrimination and harassment. But we also had a great deal of discussion amongst the standing committee and when we were meeting with the discipline administrators group that there are no law societies who regularly and possibly have ever prosecuted a lawyer for failure to report. And that is everything from failing to report discrimination harassment to failing to report suspected thefts or other misconduct by a lawyer. I think those of us who work in discipline have all heard after a lawyer is disciplined publicly, we all hear, oh yeah, we knew he was drinking, or, saw that person in the casino all the time. So this isn't surprising. We hear that after the fact, but that's never resulted, to the best of my knowledge, never resulted in an investigation or a misconduct finding by any of the law societies. It would have to be something that really rose to a pretty egregious level for any of the law societies to determine that it was appropriate to take professional discipline action against somebody for that. So I guess that's really the comments that I wanted to make about why we ended up where we did and why there isn't a specific reporting obligation under 6.3 of the rules regarding discrimination and harassment. I guess I would note as a final comment that the deletion of the catch-all in the rules, so that what was paragraph F, which is any situation in which a lawyer's clients are likely to be materially prejudiced. Another benefit of removing that is to remove any suggestion that this rule relates only to harm to clients, because of course the way the rules in regarding discrimination harassment are written, they're very clearly relate to not just a lawyer's practice within their office, and also not just in relation to their relationship with clients. It specifically includes a lawyer's duties to employees, colleagues, and others that they encounter, both personally and in their law practice. So taking out that catch-all and the removal of this reference to harm to clients, I think helps us to ensure that the rule itself is broadly applicable to all potential breaches of the Code of Professional Conduct.
Thanks,
Yeah.
Elaine. Let me just jump in with a couple of comments. First, for those law societies who might have a different view on the discrimination and harassment piece, there is alternate language in the duty to report consultation paper. It's at footnote 19. So the final language that we developed, the landing point that we would have gone to, I think, if we had concluded that there should be a specific duty to report in the context of discrimination and harassment, is there. Second, I would just make the point that it would be unusual to have a standalone duty to report for a particular contravention of the code. We have a duty to report rule that covers the code more broadly. And so if we were thinking about putting a duty to report into the discrimination and harassment section, that would have been a sort of a one-off or a standalone piece. And it was that standalone sort of treatment that we concluded would be particularly problematic in the context of discrimination and harassment because of the unintended consequences that might well arise. And so we have the duty to report rule. It applies to everything in the code. And that, of course, we have very robust prohibitions, ethical prohibitions now in the model code regarding discrimination and harassment. So that's more or less where we landed on that. So with that, questions, comments, and discussion.
Thanks very much, Carson, Claire, and Elaine. That was very informative. I took lots of notes for my thinking, and I hope this will help us in our study of the consultation report. While I wait, people can signal if they have any questions. You can do so by way of raising your hand, or if you're not able to speak into the webinar, you can use the chat. While I'm waiting for any questions to come in, I have a couple questions myself. So I was struck by what I think it was Elaine who said that, to her knowledge, no one's ever been prosecuted for a breach of the duty to report, or at least it's so rare that Elaine's never heard of it. And it made me think, could you or one of you give a little bit of context as to what role this rule plays in sort of law society prosecutions for it? I understand it's different from a complaint, like a duty to reporting because of duty to report. Is it different from making a complaint? And can you just kind of clarify how this rule fits into law society regulatory processes?
Sure. So we get a lot of calls from lawyers looking for guidance on whether or not they have a duty to report. So that's where this rule comes in most frequently is opposing counsel is engaged in X, Y, or Z. I'm not sure if that rises to the level of a breach. I don't know if I have a duty to report, those sorts of things. So that's typically where the duty to report comes in. If the lawyer determines that they do in fact have a duty to report, they can do so without becoming a complainant. So they are just reporting information to the law society for the law society to do as they will with it. So sometimes that will prompt the society to have a conversation with that lawyer to see if they intend to be a complainant, or whether they or their client would be willing to participate as a witness or informant of sorts in the process. Because often, if we don't have a participant, a witness, it may really tie our hands as to what we can do with the investigation. So that's generally how the duty to report works. we've certainly had conversations internally and with our discipline staff and at sort of more management level about what to do when we are aware that lawyers knew information and did not report. And those sorts of situations are often difficult. There's often a lot of reasons why the lawyer or law firm didn't report somebody, not least of which is a real loathing amongst the membership to tattletale on each other. There's it's especially with small bars like in jurisdictions like Nova Scotia and certainly Nunavut. Everybody knows everybody, and it's really difficult to actually have to come forward to report. So there's a lot of balancing that goes on there. Our mandate is always in the public interest, and is it in the public interest to prosecute somebody for what appears to be a failure to report? And at this point, at least in Nova Scotia, and I'm fairly confident across the province, across the country. I mean, it's been pretty consistently applied that it has not to date been in the public interest to prosecute a lawyer or law firm for failing to report.
Thanks.
I hope that addresses your.
Yeah, it does. Thank you. That's I'm learning every day about law societies and how they do their professional discipline role. It's very interesting. But I have one other question as I was going through. I think this is probably more for Claire. I understand the rationale behind changing and getting rid of the capacity language and the focus on conduct. I noticed that competence, the concept was already in the current version of the duty to report. So it's not actually new, but it seems to me it might play a larger role if the capacity piece is taken out. I guess my question for you is competence a clear enough concept to apply in this context?
Oh, that's a great question. I would argue yes, and I think given that the section on competence gives such a long list of what the aspects of a competent lawyer are, and this quality of service required to be a competent lawyer, I think if a person cross-referenced to that section, they'd find themselves able to navigate that standard.
I guess to the same extent that I mean, it would always be a little bit. It's always a little bit fact specific and multifaceted kind of thing. So I guess to the extent that it is clarified elsewhere in the code. I guess that's
Yes.
helpful. Yeah.
Yeah, and that, I mean, classic, it depends, right? And that's one of the things we talk about in the practice advice line with lawyers a lot is what does this mean and and that was another reason why, we took the word trustworthiness out, because it didn't appear other places in the code, whereas words like honor and integrity and the other words we've used, we can look to other sections of the code to inform what those standards are.
Yeah. Yeah. Understood.
This is really a section of the code that's meant to provide guidance for law society members. It's not meant to be coercive. And coming back to Elaine's point in response to your first question, the law societies are not really in the business of using this as a coercive tool for lots of reasons. It's meant to provide guidance to law society members about what their ethical obligations are. I'm not aware of any prosecutions either, and I think we talked a little bit about that at the standing committee. I think Elaine is quite right. I think there have been a number of instances that I'm aware of where law firms were contacted after the fact and said, we really would have expected to hear about this conduct a little bit sooner, and so it has given rise to discussions from time to time. So rather than using it as a coercive tool, it's been a discussion point at various times between law societies and I would say law firms, sometimes in the context of discrimination and harassment. And one of the amendments that Claire spoke about earlier has to do with, you haven't met your reporting obligations. We're making this change to the proposed change to the rule. You haven't met your reporting obligations just by reporting it to someone else. So, for example, sometimes law firms may have taken the view that their internal reporting process for instances of discrimination and harassment was sufficient, that, bringing it to the attention of the internal process, whatever that might be, would be sufficient to meet the ethical obligations. And so we've tried to provide clarity here that there's a separate obligation to report this kind of conduct to the law societies. But again, that's meant not so much to be coercive as to provide guidance.
Thanks, Carson. That's an interesting addition and nuance there. I don't see any questions in the chat, and I haven't seen anyone come forward with questions. So if not, we are coming to the end of our hour here. I just wanted to give Carson, Elaine, and Claire a chance to add any final comments before I close our webinar today.
Sure, I have a final comment, except to say thanks for the opportunity to chat about this. It's every discussion we have about this, I learned something new, and today was no exception. So thank you, Claire and Elaine, for helping me and hopefully helping everyone else as we work through this.
No, thank you for having us. And if questions come up later, by all means, don't hesitate to reach out.
Appreciate that. Go ahead, Claire.
Or to say, the process has been so constructive and deliberative so far, and we're just so looking forward to all the feedback we're going to get to make the rules even better. So thank you.
Wonderful. Thank you a final time to Carson, Elaine, and Claire for sharing your time and expertise with us. I'll also give a special shout out to Amelia Nowakowska, who is a FLSC staff member who's been facilitating here and working with me on the liaison committee as well. And thank you to the Law Society of Nunavut for organizing this. It's been, the Law Society asked for this webinar because as a small law society, we need all the help we can get in terms of understanding what's going on at the national level in order so that we can provide, informed feedback. So for the members who are on the webinar today, watch your e-newsletter. The Legal Ethics Committee will devise a process to collect feedback from the membership on this issue. So if you've got anything that you'd like to share, stay tuned for the mechanism and the time frame to do that. We would definitely welcome feedback on these proposed changes. And with that said, I'll thank everyone for attending today and wish you a great rest of the day and the week.